What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it, the state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
It's not the request.
Or is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number.
Okay.
That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it will please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.